Hello everyone, my name is Louise Rose and I'm from Think Rights, an NGO promoting and disseminating human rights. This course is a part of a series of courses made by Think Rights on companies' impacts on human rights. This course will talk about companies' impacts on land rights. In fact, Think Rights is making two land rights courses. One is an introductory course and the other an advanced one. With this video, I want to clarify some of the terms I use in the courses and give you the broader perspective of why land rights are key to some of the world's most pressing development issues and challenges. The course will exemplify some of the issues related to land rights by taking you to the Solomon Islands in the South Pacific Ocean, where the palm oil industry is having adverse impacts on local communities and their land rights. In the land rights courses, you will hear me talk about the Global North and the Global South. This is also known as developed and developing countries. Okay, let's begin. Virtually all land around the world has rights. Land rights were secured historically in different ways around the world, and in most places this did not include a piece of paper. Insecurity of ownership came when different cultures entered through colonialism. The sense of bringing progress, modernity, and development to the poor, and consequently the idea that there was a better way, the European way, of securing land rights is the historical context of the land rights problem we face today. The sense of bringing progress continued when multinational companies entered those countries in the Global South, and the problem of not having land rights formally recognized emerged. This difference in understanding of what is making land ownership secure is actually at the base of the problem, and this is what clashed between companies and local communities. So now you might want to ask, why are companies even looking for more land outside of their country? You see, with a worldwide growing population, the demand for arable land for food production is rising, and this is causing a great pressure on land. Land is also taken to extract other resources, such as the minerals in our phones and computers, and oil and gas to provide for our energy consumption. This is just some of the examples of what is causing a great pressure on land. So land is becoming a scarce resource, and this has caused conflicts and grievances to arise over land. In the Global South, many people have been displaced from the land where they have lived for decades, as well as their ancestors before them. This displacement has taken place in order to make room for multinational companies to come in and take over the local community's land in order to run their business operations, so that they can produce food and other materials to meet the global demand. So now you might be thinking, how are local communities impacted by companies taking over their land? For many local communities, land is life. Growing crops and harvesting fruits and nuts from the forest are just a few examples of the activities that millions of people do daily to get food on the table or to earn a living. But when their rights to that land are not respected, food sources and livelihoods can get very insecure and can disappear from one day to the next. Maybe you have never thought about the importance of land rights and simply taken them for granted. But when your livelihoods depend on it, you don't have this luxury. So land rights have always existed, but to be able to securely use the land, local communities depend on recognition of their existing rights by others, like the state or companies. This can be done in different ways, for example, orally agreed or written on paper. There is no one-fit-all approach. Even if some of us may be more familiar with contracts and deeds registered in land registering systems, for many local communities, relying on historical, social, and oral agreements provides more security to their land. These rights are also called tenure rights, and they define who can use what resources for how long and under what conditions. In order to secure tenure rights, we need to have a system that governs and protects these rights in case of challenge or violation. These systems are known as land governance systems. In the course, you will hear formal and informal land governance systems. And this is really just to explain the difference between written and oral, or statutory and customary ways of governing, respecting, and protecting land rights. Let me give you some examples that will exemplify the difference between formal and informal land governance systems. Most of the land tenure in the global north is governed by formal land governance systems. Although I should briefly add that historically this has not always been the case, and still today land is also recognized through informal land governance systems in some places in the global north. So going back to what is a formal land governance system, this includes public authorities that manage, allocate, and oversee the transfer of land and provide sanction mechanisms. This could be land administration offices and land ministries. The rules and processes made by the public authorities are written in the country's constitution, statutory, and regulatory frameworks that govern tenure relations amongst people. Let me give you a concrete example. If a family either buy or rent a house, they will also buy or rent the land that the house is built on, and maybe even a garden or fields that belongs to it. The size of this area is measured and registered, and the coordinates will be saved in the National Cadastral System, which is the land registering system. These records are then kept at the land ministries or the land administration offices. Before moving into the house, the family will sign either an ownership or leasehold contract with the owners of the land. The ownership or leasehold contract is a formal document and a legal instrument which confirms the allocation of tenure rights and formally recognizes the family as the new landowners or tenants. This documentation is important in case that land disputes between contrasting interests emerge and when the case is submitted to national courts. When we are talking about formal land titling as this, we are actually only talking about 30% of the world's population whose land is secured in this way. The rest of the world's population has land that is governed by informal land governance systems. The informal land governance systems can be based on a variety of non-state institutional arrangements, such as customary religious or other informal institutions that manage, allocate, and transfer land. What these informal land governance systems have in common is that they are often based on historical knowledge, oral agreements, and the recognition of belonging to the informal institution. These agreements and relationships are rarely written down, and the knowledge is instead passed on to future generations orally by traditional authorities. These authorities could be priests, clan or tribal chiefs, or groups of elders. So bear with me for the high degree of simplification, but we could say that land ownership in the global north is mostly at individual or household level, whereas in many parts of the global south, ownership over land belongs to communities. Communities can be clans or tribes that can orally present proof of stories of how their ancestors acquired the land decades or even centuries ago. It is in fact the identity of belonging to specific clans or tribes that defines whether or not you have permission to access and use customary land. Since land tenure in the global south is very local and might vary from one village to the other, depending on traditions amongst communities, clans or tribes, it is really difficult for outsiders to engage with it, as there is no paper, which was the familiar way for colonialists and is the familiar way for multinational companies to recognize land ownership. So for outsiders like companies or states that want to acquire land that belongs to communities, it is therefore key to meaningfully engage and involve in a participatory way with the communities who have rights to the land at the initial state when the project is conceived. I can give you some examples where meaningful participation of communities did not happen and conflicts emerged. Colonialism is an example. Shifting cultivation is a traditional practice used in many parts of the global south, where bigger pieces or even areas of land are let to fallow for between 5 to 20 years. In the colonial times, when outsiders discovered some of these fallow areas, they defined them as vacant land and available to use as it pleased them. This, of course, led to grievances among the local and indigenous communities whose informal land tenure rights were not recognized by the outsiders. The outsiders came with the idea of modernizing traditional agricultural practices and consequently introducing their way of securing land tenure, which was mostly formal through land titling. Land grabbing is the new colonialism. Today we actually see the exact same history repeat itself, but instead of colonial actors, we see powerful companies taking over local communities' land without recognizing their tenure rights. Land grabbing, also known as large-scale land acquisitions, are the buying or leasing of large pieces of land by domestic or transnational companies, governments, and powerful individuals. Land grabbing is a severe issue that takes place on a global scale. Despite of the global reach of land grabbing, there is no complete definition that fully captures the issue, and there is no official definition that has been accepted as the complete one yet. In the land rights courses, we want you to learn about the phenomenon of land grabbing with a focus on the severe impact it puts upon local communities in the global south. So our way of working with the phenomenon of land grabbing is when companies don't meaningfully engage in consultation with local communities and seek their consent before starting business operations. Although now, the consent part is only recognized to indigenous communities through the free, prior, and informed consent principles. These are all topics that you will learn more about in the land rights courses. In fact, all the different terms and topics that I've talked about in this video will be elaborated in the land rights introductory course. I hope you found this introduction video interesting and that you are fueled with curiosity to take the remaining units in the land rights courses. Please feel free to reach out to me if you have any questions regarding the content in this video or in the land rights courses. Thank you for now.